Good morning, everyone. Thank you so much for joining us this Friday for our Domestic Violence Training Series Part 3. Today, we'll be talking about domestic violence and legal considerations for the immigrant community. This is the last webinar of our training series. We've uploaded Part 1, which was Domestic Violence 101, and Part 2, Domestic Violence and Impact on Children, on our website at homevisitingla.org/webinars. I will paste it for you all in the chat, just so it's easier to access. For today's training, we're going to be talking about the legal considerations, especially for the immigrant community, and our speaker will share her experience working with domestic violence and immigrant survivors. We will also learn how to effectively respond to domestic violence among immigrant survivors. We will learn about barriers related to reporting, cultural considerations, and how immigration status is used as a weapon to control. And then we will lastly be provided with options to share with immigrant survivors, legal remedies, and victim rights. Just a few housekeeping tasks before we get started. Please use the Q&A chat if you have any questions for the speaker. We will have time at the end of this webinar to answer any of the questions that you have. And then please use the chat to introduce yourself, as you all have been doing. Let us know what organization you're from, and things like that. And then this webinar is recorded, and all the slides and handouts will be sent out to those on the call early next week. And then lastly, at the end of this webinar, you will be prompted to a survey link evaluation. Please take a few minutes to fill out the evaluation after the webinar is complete, as it lets us know what trainings we can put on for you in the future consortium-wide, and then which ones are really beneficial for you and your community. All right, with all that being said, I just want to say LAVPN and the consortium is extremely grateful to be partnering with Peace Over Violence for this training series. Our speaker today is Lizeth Castillo. A little bit about Lizeth. Lizeth is the managing attorney of the Legal Assistance Project at Peace Over Violence. She's an immigration attorney specializing in providing immigration relief for survivors of domestic violence, sexual assault, and human trafficking. She has been practicing immigration law for more than 10 years. Before joining Peace Over Violence, Lizeth was an attorney with the Immigration Center for Women and Children in Los Angeles and New York, Legal Assistance Group in New York City. Lizeth, thank you so much for joining us this morning. I will pass over the mic to you.
Good morning, everyone. I'm so happy to be here and hoping that I can provide some insight into this very, let's call it delicate matter, right? It is incredibly delicate working with immigrant survivors. When we're talking about domestic violence, we're already dealing with a population of a community that is so underserved and in need of nourishment and support, and adding an extra complex layer of undocumentation in a country where it becomes increasingly violent and difficult to be undocumented in this country is not an easy task. So I'm going to try to make this as comprehensive as possible and as accessible as possible. But of course, around, I don't know if any of you deal with lawyers very much, but one thing that is notoriously difficult about getting answers from attorneys is that the answer is always, it depends, right? So here, just know that while I'm here to offer legal information, anytime that we get close to offering legal advice, or if the specific narrative that you have sitting on your mind is very specific, I'm gonna have to hit you with an it depends, because very few things in the legal environment are ever straight yes or no answers, especially when we're talking about immigration, which is such a volatile area of federal law. So I will do my very best, though, to be informative and helpful. It's always what I strive to do. One of the reasons that I became an attorney in the first place, especially working with the immigrant population, is because I believe that information is the highest form of access, is the highest form of power. So when we are informed, we are autonomous, we are sovereign, and we hold a key to our own empowerment. So let's try to move through this with that perspective in mind. Okay. I guess we can start with what the objectives are today. I'll go over to the next slide. I don't know if I can move it. Oh, perfect. Thank you. Okay, so first I want to talk about just some considerations when we are working with survivors, right? Things to just sort of keep in mind when we're in this arena of not just domestic violence, but if you know for sure, suspect that a survivor's documentation status may be also at play in the dynamics of your interactions. So there are common barriers to self-identification, and this is not only self-identification as a person, but also as a survivor. I mean, not a survivor, an immigrant, I'm sorry. Although add in the extra layer of also maybe, somebody that you're working with kind of being hesitant to even come out as a domestic violence survivor. When we add in a lack of status, right? There's so much fear that comes involved with that. So when I'm talking about barriers to identification, I am talking literal, as in especially recently arrived immigrants. A lot of them do not have documentation of their own identity, right? Their passports are taken away at the border if they are apprehended by ICE. And most, if not all, of Central Americans coming in recently are having difficulty accessing their documentation through their consulates here. So we saw during the pandemic consulates just across the board start to shut down. This was happening even amongst the biggest ones. I mean, even Mexico, we have such a huge Mexican consulate presence in the United States, and so many of them were also shutting down during the pandemic. But a lot of smaller Central American countries, mixed with a combination of violence that was happening in respective countries of origin, we've just been seeing consulates start to shut down services or slow down services, and it has not picked up post-pandemic. So many undocumented survivors quite literally are not able to self-identify. They're not able to get identifications in California or other states. They're not able to get copies of their birth certificates if they didn't leave their country with them, with very little access to family members that have the resources to go get copies for them. They don't have their passports to be able to prove their identities because they either never had one or it was taken away from them at the border. So getting identification documents from recently arrived immigrants can be very difficult. On top of that, they also may not want to identify as an immigrant, right? They may have their own understandings or beliefs about the danger that they would be adding to actually say, yes, I am undocumented in this country. It is the number one barrier to access that to services that we find, right? Is that so many folks would prefer to be under the radar and not at all explain that they are in fact undocumented. And so screening for that need, it can be incredibly difficult as well. And so, and then again, adding in the last layer of many of them not wanting to identify as survivors of domestic violence can also mean that a lot of times people need resources, need help, but they can't communicate those needs. Another thing that is difficult is a barrier to reporting. This is various reasons. This is why having this cultural component is also so important when working with immigrant survivors, because you have to understand the landscape from which they were bred, right? Domestic violence is one of the increasingly protected statuses in asylum law, right? Where we are finding that domestic violence is so rampant in other countries that it quite literally functions like a plague upon the country, in which the government is not doing anything to protect them. While there may be a legal structure for protection against domestic violence in certain countries, there is no actual implementation of that law. And so what we're up against when we're talking about wanting survivors to come forward and report to law enforcement is a cultural dynamic in which that they're told that women's rights just don't matter, that domestic violence doesn't matter, that it is just a thing that happens whether or not it's illegal, and that there is very little that the government will do to protect you. And so, especially when we're talking about recently arrived immigrants, this is the mindset that they're coming into when they immigrate to this country, right? That might not entirely be the case in the United States, but that is still what we're working against when we're trying to help the immigrant population report domestic violence at all. The next is to just be more mindful of trauma-informed care, right? Working in the legal industry is very difficult because trauma-informed care is one of the things that we try to figure out, well, how can we do this best, right? when what you need more than anything from a survivor are answers, and wanting to just get them as straight, as detailed as possible. How can you practice trauma informed care while still getting what you need in order to successfully advocate for a survivor in the legal field? And the first answer of the day is it depends, right? It really does depend. There are some times in which our objective is not to avoid retriggering altogether, but to navigate representation with as minimal triggering as possible, right? Or to be able to provide aftercare and connect with aftercare services so that once we do engage with a survivor, we're able to help them ground, help them, reestablish their feelings of safety and security. But trauma-informed care, when working with the immigrant population and, especially in the legal field, looks a little bit different than it does when we're just talking about providing services for like counseling, social care, all these other things. And it's important to just understand that, right? We're also going to discuss the legal remedies for immigrant survivors because there are some very specific ones that apply, humanitarian legal remedies that are specifically for survivors of domestic violence. And then it's also important to just understand that maybe a lot of survivors just don't really understand what their rights are in this country. There is also a general assumption that because they are undocumented, that means they have little to no rights at all, and that is simply not true. Especially true in states like California, where we have worked really hard to widen legal protections for immigrants, regardless of their status. But also true in other very progressive and forward-thinking states like New York, where there are also a large number of protections afforded to immigrant populations. So half of the battle sometimes is getting folks to understand that just because they're immigrants does not mean that they're completely devoid of rights in this country. And then the next is VAWA confidentiality. So the Violence Against Women Act is a very unique piece of legislation that has both an immigration law component and a social component. The immigration component is what gives folks the capacity to seek legal remedies through the Violence Against Women Act. But there are also social components of this called VAWA confidentiality that work at a very high standard, right? And so when government agencies are working with immigrant survivors, they are afforded high protections against divulgence of their status as undocumented or as survivors at all. And so it's important to understand these in case there's ever some sort of breach of confidentiality, but to also understand that they exist and that they are powerful protections for survivors of domestic violence. Move on to the next one. Okay, this is the Immigrant Power and Control Wheel. So if you have never seen it, I'm sure that many of you are well acquainted with the Power and Control Wheel and the various adaptations that have sort of sprung from the original, each of them trying to encapsulate like all of the different subtleties of working with different populations. But this one specifically is for immigrant survivors. And so you'll notice that there are not just variations on economic abuse and physical abuse, but there are aspects to this that involve holding the person's legal status over their head and using that as a means of coercive control as well. So we will go into this into more detail about the different ways that coercive control can come in when we're talking about legal status. But I just wanted to give you the visual so that you, one, know that it's out there, and two, can just sort of begin to see how it shapes interactions. Okay, next slide, please. Okay, so let's talk about the barriers to self-identification. Some of these I've already identified. I do just want to, take a moment here to also weave in. I did receive some of the questions that folks had before the webinar, so I'll take moments to weave that in these as well. But again, we've already, like I mentioned before, many folks might just not want to identify as being immigrant for a lot of different reasons, right? There are also some misconstruction or misunderstandings around if I identify as an immigrant, if I tell somebody that I don't have status, then I won't be able to access services, right? The the biggest way that I've seen this manipulated when we're talking about working with immigrant survivors is in respect to housing and emergency shelters. So in California, we have really afforded a lot of protections for survivors, and we have made it law to for certain agencies, law enforcement agencies, government agencies, to not be able to deny services based on immigration status. And this also extends to shelters. There are some misconceptions that because folks don't have immigration status and are not able to prove their status otherwise, that they may be able to be refused emergency housing or shelter services, and that is absolutely not true. And in fact, there are ways to report discrimination of this specific kind to the Attorney General, because there are specific laws in place that say you cannot discriminate based on immigration status. So if you do ever find yourself in situations where a client or a prospective client is telling you that they fear being turned away at shelters because of their immigration status, you can safely tell them that that is just against the law and it is not true, right? We have also enacted in California certain protections around law enforcement being able to ask about a person's immigration status and the courts being able to ask. So as it stands right now, law enforcement agencies are not supposed to ask the person's immigration status when taking a police report. And again, there are ways to report this when when it does happen. I'm not going to say that just because it's against the law means it never happens. Of course, we all know that that's not true, right? But there are ways to report this to supervisors, to higher ups. This kind of stuff is absolutely tracked by the Attorney General because California has an invested interest in protecting immigrants. Like our state government is very aware of its cultural landscape, and community members, organizations similarly structured to peace over violence that provide legal services to immigrant populations have been advocating for decades to continue expanding rights to immigrant survivors, and so they do exist. And while we're still finding that the tides have not completely shifted and that we still have to advocate with law enforcement agencies and the Attorney General's office and all of these like smaller government agencies to remind them that protections are necessary, there is forward movement and things already exist and are in place to protect against discrimination of this kind, right? So there is also, for example, there's also access to medical care. This was a recent change that we saw in California where now immigrants do not have to show proof of status in order to receive full scope Medi-Cal. So before we saw that only if you had like certain humanitarian applications could you apply for full scope services. And that is generally still the rule, but at least now emergency medical services are available on a full scale, regardless of immigration status. So it's becoming more and more safe for immigrants to actually even identify as immigrants without fearing withholding that information because they'll be rejected for services. We already spoke about the reasons why a survivor may not actually identify as a survivor, all having to do with cultural associations that may not even, they may just believe that identifying as a survivor isn't going to be helpful to them, and that law enforcement isn't going to protect them, that the court system is not available for them, and we know that that's not true, right? So I mentioned before too that the courts are not allowed to ask about immigration status. So if a survivor needs a restraining order, if they need to seek custody of their children against their abuser, they can do so freely without worrying that these things are going to be held against them in court. They may also be fearful of offering services, right? Especially when we're talking about one of the things that I think we would be really remiss to not acknowledge is how much damage the Trump administration did to the safety that survivors, or that immigrants, I'm sorry, felt in this country, right? And one of the things that I feel personally is still kind of recuperating is the trust that certain spaces are in fact protected from ICE enforcement. So things that we know in the public are in fact safe are things like public schools, churches, hospitals, shelters. In those public spaces, ICE is generally not allowed to go in to enforce or do raids. Unfortunately, during the Trump administration, we were still seeing that happen a little bit, even if these were previously protected spaces. So, we're still battling against some of the things that happened during that term, and for that reason, survivors may just be fearful of actually receiving services because they've heard stories of people being arrested at the courthouse when going for a restraining order, right? They've heard stories about, um, you know, adults being swept up when picking up their kids from school. Like we've heard stories of this, right? But the hope is to just sort of understand that those fears exist for a reason, and that if we can identify the sources of fear, then we can do our best to assuage those fears, right? To just sort of tell survivors, like, you have rights. This is what they are. This is your rights in publicly protected spaces. And just, again, access to information is the highest form of power. And so, lastly, an unstable home environment may make it difficult for follow ups or continued connection, right? So, here, especially, I see this a lot when working with children, when working with youth who are recently arrived. Unstable home environments, wow, it's almost as if these kids just sort of are so susceptible to falling off of the radar, because they sometimes can come into spaces where they just met family members that they are now living with, and if that home environment is already not safe and stable, it may just be difficult to really conduct any kind of real follow-up for services. And so sometimes when working with immigrants, the very first interaction that you have with them can be the most potent, and sometimes is the only time that you really have to fully assess what it is that their needs are. And it's a really unfortunate reality of working with this population, is that sometimes it feels like there's just not the space, right? For all of these reasons that we've identified, that there is just not the space for continued connection and continued assessment of their needs. This population, more than any other, I find, is very difficult, is very easy to fall off the map, right? To have like one interaction in which you're just explaining all of this, and then the next time that you try to call for a follow-up, all of a sudden they're just not there. And that is very common. And I think the more that we are able to just like address that it is a common thing, the more then we can keep that in mind when we are implementing programs and structures when working with a specific population. Next slide. Okay, so now barriers to reporting. I already went through some of these, so I won't rehash it. But again, harmful government in their country of origin may also be the biggest barrier to reporting. Next would come a general distrust of police, right? We have to think about what that government enforcement looks like in their country of origin, because that is what they're coming with, right? That is the bias that they are already coming into when we are asking survivors, immigrant survivors, to feel safe in this space. Next is a fear of deportation. This is still a common thing, no matter how much we try to really put it out there to the immigrant community that they can report domestic violence without fearing deportation. It is still the number one way that abusers hold power over their victims, right? Is they continue telling them, if you call the police, I am going to tell them that you are the person who hit me, and they're going to deport you, right? We still even see this with when the abusers themselves don't have status, that they still can somehow tell the other person that they're going to report them to the police, and the police are just going to come and take them away immediately, right? And again, some of this is amplified by what we saw happening in the Trump administration, where a lot of local governments, a lot of like local police were actually working with ICE to enforce mass deportation. So we unfortunately, when we're working with the immigrant community, even a few instances of community-based violence in this way, like throw us back so many decades of advocacy and work that we've been doing to build a healthy community and a safe community of immigrants. So again, I'm only bringing these to the surface to recognize that these are just things that we need to keep in mind when we're working with survivors, right? The fear of deportation is still so strong. And we saw that at an all-time high during the Trump administration, but surely it was not just there, right? I mean, it was also, we were having mass deportations happening during the Obama administration silently, where people really weren't even paying attention. But then, the next few years is when it really started to amplify, and the voices of the communities really started speaking out with rage. So the next is also a misinformation spread by community or abusers, right? I see this so much. Like sometimes the hardest thing to fight against is like that friend that you know that told you about this one thing that happened, right? And this is why it's just so difficult, because in nothing in immigration is like so linear, where like one case you may have like a set of circumstances that look exactly the same as another and yet have a completely different outcome. There is nothing guaranteed in the way that immigration works, and unfortunately, that misinformation that says like, oh well, like you can do this because I heard from a friend of my friend that she did this, right? That kind of community misinformation is sometimes some of the most detrimental that we have to fight against, right? Misinformation about a person who reported to the police and got in trouble, misinformation about a person, who turned themselves over to immigration and then had a successful outcome, or whatever it may be, right? That misinformation spread by community members really amplifies a lot of the fear that's already sitting in these communities, and it does not help us. And again, this is why I continue to say like access to information is the highest form of power, because if you are the person able to give information so that they don't have to hear it secondhand, and that you are empowering that person with straight information. Next is one that I'm sure we all know very well, is the fear of DCFS and other similar structures that can take children away, right? And unfortunately, this is one of those things in which we do see the DCFS in the immigrant community, like they just do cause more harm than good a lot of the times. And DCFS is already a difficult organization sometimes to work with, because they are working under a completely different model of care. But when we're adding the already present fear in the immigrant community, it's really just it starts to fester in different ways. And so I do know that one of the things that we are talking about in the legal community is about access to family law services and quality attorneys, right? This is one of the things to understand about immigration and family law, is that there is no right to an attorney, not in the same ways that there are in like the criminal justice system, right? And so while children who are in dependency and dependency hearings have a right to an attorney being assigned to them through county council, the same is not true of the adults. So adults are sort of out on their own, and they do not need they're subject to either spending a lot of money on family law attorneys, or trying to struggle for free family law services, which are incredibly difficult to get anywhere, especially in Los Angeles, because the needs are just so high. So this is a continuing conversation within the legal community about how do we really address the availability of quality services for family law in Los Angeles, and to counterbalance some of what's happening on the other side when local government gets involved in family law proceedings. And we don't have an answer to that yet. We don't. It is just one of those things where the legal community is going to have to shift its priorities in a lot of the same ways that we saw happening with immigration, right? Where all of a sudden a lot of nonprofits were focused on providing immigration relief for survivors, and a lot of that was free of cost. And I personally hope that we see a tide similarly happen in the family law area, right? But so far, not so much. So far, it is still an incredibly difficult arena for survivors to access for free or reasonably priced services, quality services. And so the last one is that a person's immigration status may actually be tied to their abuser, right? Regardless of what a lot of folks think, the immigration system in the United States is very difficult to access. It is not easy to get immigration status legally in the United States, especially not when you were already here. So it is already difficult just getting access to entrance to the United States when you were outside of the country, right? Things like tourist visas, employment-based visas, family-based visas are already difficult and limited by number and structure. But when you are already in the United States illegally, meaning that you entered without being inspected, entered without an actual visa, a lot of the system is just not available to you. So it is incredibly difficult. And survivors who already are trying to engage in this process are well aware of how difficult it is. And so when their status is already attached to this person who is hurting them, they often feel as if they have no other way to run. Next slide, please. Okay, so speaking a little bit about trauma-informed care, because I did give you the caveat at the beginning, the trauma-informed care when we're talking about providing legal services can look a little bit different, right? So here are just a few tenets of trauma-informed care as it applies to working with survivors with legal needs. Here Number one way that we can offer trauma informed care is to alert survivors of their rights with police, immigration, language line access, all of these different components. We empower survivors with knowledge to avoid another cycle of control, right? And by that is not just by their abuses, but by even other local city, county, whatever agencies that sometimes are just not aware of what a person's rights are, right? That is another common thing that happens is that even though there are structures in place to provide support services for survivors, sometimes we're finding that the people who are on the ground responsible for engaging in that care are just not aware, right? And if they're not aware, then we put survivors in a situation in which they have to really self-empower with that knowledge and really be able to advocate for their rights. The next thing is probably one of the things in which we try to reduce retriggering. It's to reduce storytelling. And if you need sensitive information that's not being provided, then you can just inform the survivor as to why you need that, right? This is like the thing that is the most difficult. Sometimes, especially when you're assessing for legal services, you can't avoid having to ask certain questions because certain questions are the foundation for their eligibility for services. And so when you know that you're going to have to ask a question like, well, for example, if you're assessing for like a UV visa or a VAWA, there are certain factors like physical harm that are necessary, right? Like I need to know the difference sometimes between whether you were punched in the face or whether you were yelled at. And while those two are both domestic violence, one is a very different part of the criminal system than the other. And one may make you eligible for a UV visa while another may not, right? And so sometimes I find myself having to ask these very intense questions that feel inappropriate but are necessary in order to assess for eligibility. And so when you ever find yourself in that situation, absolutely the best thing to do here is to inform the survivor as to why you absolutely need that information. And the best way that I like to do that is I say, I know that this is very difficult to discuss, but this is something that I absolutely need to know from you in order to be able to thoroughly assess your case, right? And if you can even go into further detail as to why that information is necessary and how it will be helpful for you to have the truth, then that is trauma-informed care. And that might look differently than how we avoid storytelling in certain spaces with survivors generally, in the interest of not retriggering. But this is the best that we can do when we're talking about, again, needing to get information in order to assess for eligibility. And the next is going to be to create appropriate safety plans because you may need more than one, right? There are different factors for the immigrant community. Safety planning may not just be about getting you to a safe space, getting you to a shelter. How are you going to find clothes, foods? Like those are all great safety plans, but there are also additional considerations that we need to talk about when it comes to immigrant survivors, right? If they have children and they are undocumented, you may need a whole separate safety plan for what happens if they are, if they are detained by police, and then their immigration status becomes questioned, right? This is something that like family law practitioners really started to pay attention to during the Trump administration because we actually became aware of how regular safety plans don't take into consideration like a person's immigration status. That you may need to have a safety plan directed at like, well, what happens if I'm taking into ICE custody? What happens to my U.S. citizen children? Who do they go with, right? And especially when the father of those children or the other parent of those children are the abusers, right? We can't just leave to the other parent to be the one to take accountability for those kids. There needs to be some other backup in place. And so you may need a safety plan for that. You may also need a safety plan for what to do if an immigrant survivor needs to flee and can't have access to their documentation, right? One of the things, for example, one of the things that I often discuss with respect to safety plans for my clients when they are still living in the household, right, and they want to prepare filing for VAW or a U visa or something, I have to have a safety plan in place for what are you going to do if your partner finds your documents, right? If you start receiving like for example, I make no I make absolutely zero requirements for my VAWA eligible clients to leave the marriage that makes them eligible for VAWA services. It is not my, like, I am not the gatekeeper here. I'm not going to be the one to say, like, you have to leave that household in order for us to be able to file a VAWA petition for you. But it is my responsibility to, like, make sure you understand that you're going to be receiving things like a work permit, like appointment notices for immigration and things like that. Do you have a safety plan in place for if if your abusive partner ever finds that, right? Things like that. Or for example, if a person is VAWA eligible and they're still living in the house, there are certain documents like evidence of joint residency, that person's evidence of that person's status, like all of these different things that may not be accessible if they decide to just leave one day, or if they have to leave one day super hurriedly. And so, I have safety plans around my clients for saying designate a safe person to send your sensitive documentation to, the things that you know are going to be necessary for you to be eligible for legal services. Send them, store them somewhere with a third party that you know is safe, right? Again, these are just different types of safety plans that are either in addition to or completely separate from the traditional ones that we find for survivors. The next is going to be to remain flexible, as disorientation when working with immigrant survivors is so high, is so high. And this is not only because of the cycle of abuse that we see, where sometimes they are still riding that cycle pretty intensely. But there are in the immigrant population, there are just so many emergency needs that all come to the surface. And one of the most difficult about working in this sector is that survivors, they have a different list of priority when preparing to leave or after recently having left their abuser, right? Some of them may come in saying like, I need legal services and that is at the top of my concern. But when they don't have shelter, when that they don't know where their next meal is coming from, when that they are just not in an emotional state to be able to talk about some of the really serious things that we need to know, sometimes I have to be super flexible and say, like, I understand that this is your priority right now, but I also need to, get you in these other services in order for us to have effective and constructive communication, right? So we have to be flexible to those priorities continuing to shift when we're talking about immigrant survivors, because it happens so often. And then last is ensuring language access, which is such a big thing. Being able to receive services in your language, in your native language, is such an important thing for empowerment. And so I gave the link here for a government LEP toolkit that can identify how to get and how to ensure language access for services. So certain government agencies are required by law to give access to services in the language of the survivor. Again, do we always see that happen? No. But this toolkit is very helpful in identifying how to get language access and what to happen if you come across agencies that are not upholding the requirements. Next slide, please. Okay, so now we're going to jump into legal remedies. So this is not a wide sweeping list of legal remedies for immigrant survivors, but they are the most common. I'm going to talk a little bit about each one. I'm sorry, could you just forward to the next slide? I want to remember whether I go into detail in the slides or not. No, I don't. Okay, can we go back? I didn't think that I did because they are fairly complex. Oh no, now we have to go. Okay, good. Perfect. Thank you. Okay, so I'll give a very broad review of these, and I am very open to answering questions about specifics. But again, just remember that the most that I can provide in settings like this is going to be legal information. So the U visa is the most common that we find in the immigrant community for survivors of domestic violence and sexual assault. So the U visa and T visa are very, very similar. They are both housed under the TVPRA, and they are for survivors and of domestic violence, sexual assault, and a wide array of other what's called qualifying criminal activity. But both of these were forged in order to encourage cooperation between law enforcement agencies and the immigrant population. There was a recognition on behalf of government that there was just no reporting happening. that there was a lot more crime that was afflicting the immigrant community than what was being reported. And so both the U and the T visa were passed in 2006 in order to try to bridge some of that connectivity between immigrant populations and law enforcement. Now, this will always continue to be a very tricky piece of collaboration, but is ultimately one that I do believe has helped the immigrant population and law enforcement just become open to working with agencies like POV and similarly structured for training and understanding about the very specific dynamics that happen in immigrant populations facing high levels of domestic violence and sexual assault. So the U visa, it comes about from a person's reporting and cooperation with when they are the victim of a qualifying criminal activity. So, like I said, domestic violence and sexual assault are the highest ones here, but we also have human trafficking, we have stalking, we have attempted murder, arson, kidnapping, like all of these different qualifying criminal activities, most of which are felonies that are qualifying crimes for the U visa. And so basically, in order to be eligible for a U visa, a person has to be the victim of one of those qualifying criminal activities. They have to report it to law enforcement. They have to be cooperative with law enforcement throughout the investigation of that crime. And they have to be able to show that they suffered substantial abuse as a result of the qualifying criminal activity. So those are the basic requirements. How this actually ends up looking is that when a person comes to receive services or is interested in services and we identify them as a survivor of one of those qualifying criminal activities, we then have to work with law enforcement to provide or to request something that's called a certification, a U visa certification that confirms what crime the person was the victim of, confirms that they reported it to law enforcement, and confirms that they were cooperative throughout the investigation, and also can list specific injuries that were recorded in the report. Now, there are a number of different law enforcement agencies across California and across LA County. Law enforcement agencies are not just the police. It also includes things like, so we have LAPD and LASD are our highest, right? But we also have the District Attorney's Office, the City Attorney's Office, DCFS, and the Superior Court when folks have been receiving restraining orders, okay? So those are our highest law enforcement agencies in LA County. Of course, we also have the smaller police precincts in the Outer Banks, like the LA County, but not LA City agencies. And so when we get that certification request from them, that is absolutely the first step and the most vital in the U visa process, because without that, we cannot file a case. So without that certification request from law enforcement, we have nowhere to go. And so the U visa generally, so since its inception, it has gained in popularity. All non-immigrant categories, meaning temporary status in the United States, is subject to categorical limitation, meaning that that immigration can only approve a certain number of cases per year. They can only give out a certain number of visas. And the statutory limitation for both the U and T visa is 10,000 a year. So only for each fiscal year, USCIS is only able to approve 10,000 visas. At the beginning, when the U visa was passed, easy peasy. But since around 2008 to 10, we have seen an average of 25,000 cases filed per year. So you can easily see that over the years, the wait time for a U visa approval has gotten substantially longer. At present, we are expecting adjudication on a U visa case around 6 to 9 years. So it is an incredibly lengthy wait. There has been litigation around the processing times of the U visa for many, many years, which has not resulted in USCIS or the Department of Homeland Security increasing this categorical limitation on the visas. However, what we have been able to get is temporary work permits for survivors after their U visa is initially submitted. So before, how it was working is that USCIS wouldn't even give work permits, the temporary work permits, so basically DACA, until an officer picked up the case and kind of a sweeping review of it. And now, thanks to decades of litigation, I think lawsuits that have been pending since about 2013, 12 to 13, we finally saw get approved and through the system around the end of 2023, where USCIS started implementing temporary work permits right after a case is filed. So USCIS will do a very, very cursory review of a U visa petition after it's initially filed. And if the person seems to have all of the basic requirements, then USCIS will give what's called a bona fide determination, a notice that says you seem to have all of the requirements, and issue a 4-year temporary work permit until their case is adjudicated. Now, the expectation would be that within those 4 years, an officer is able to pick up the case and start adjudicating it. But if that does not happen, then that person can extend their work permit until they have an approval of their U visa. After, like, let's say 6 to 9 years down the line after that U visa is initially submitted, that person is given U non-immigrant status that is valid for 4 years. They must remain in the United States that entire time without leaving, and 3 years after their U visa is approved, they can then apply for a green card, and then 5 years after getting that green card, they can apply for naturalization status. So while it is a very long road to wait for the U visa, ultimately it can get a person to citizenship without having to leave the United States, which is one of the biggest factors of the U visa, and without ever having a single interview with immigration. It is all done by paper. So while it is incredibly long, it is a very like agreeable and amenable type of immigration relief. You can also apply for waivers of a bunch of different what's called inadmissibility factors. Basically means that, you know, if you were working in family-based immigration, you would be ineligible to apply if you ever had criminal history, if you entered the United States illegally, if you had any kind of like certain health related concerns and things like that. And all of those are waivable under humanitarian law under the U and T visa. So T visa is very similar to the U in structure. The only difference here is that the T visa is specifically for survivors of labor and human trafficking. Labor and sex trafficking. So those cases are specifically, while the U visa has sex trafficking and labor trafficking as one of the qualifying criminal activities, when we have folks that are survivors of those particular crimes, we prefer to file them under the T visa because that does not have as much of an egregious wait time as the U visa. Right now, the T visa is somewhere around like 1.5 to 2 years. So it is not as lengthy at all. One of the biggest differences between these two as well is that while that T visa certification is recommended, it is not a requirement. So that is one of the biggest distinctions between these two. If you can show that a survivor of human trafficking was trying to report their trafficking or was unable to due to extreme trauma, then we don't need the T visa certification, and that is just not true of the U. With the U visa, it is a hard line requirement. And so moving on to the VAWA self-petition, and actually it's worth noting as well that VAWA came first. So the Violence Against Women Act actually came before the U and T visa. And the part of the legislative predecessor for the U visa was in recognition that a lot of people were left unhelped by the Violence Against Women Act, right? The Violence Against Women Act requires, it is a very similar and parallel experience to a family-based application. In a what we call a traditional like family-based immigration case, if you had two people who were married, the U.S. citizen or lawful permanent resident spouse, so the person who has a green card or is a citizen, can apply for their undocumented partner, their undocumented spouse, and that is what a normal, like a traditional family-based application is. But when you have domestic violence that enters, VAWA comes along in order to allow the VAWA self-petitioner to put forth their own application, right? Sponsor their own green card based on the domestic violence. But the requirements here are that the person be married, so that the VAWA self-petitioner be married to either a U.S. citizen or a lawful permanent resident, to be able to show proof of that status, that they were at some point in the relationship living together, And I should also note that for the marriage requirement, this is a marriage that is recognized where it was performed. So VAWA does allow for certain non-traditional legal marriages here. That they were living together at some point throughout their relationship, that the person suffered battery or extreme cruelty at the hands of their US citizen or green card holder spouse, and that the person be a person of good moral character, okay? So there is no requirement for police reports, restraining orders, any of that with the VAWA self-petition. While it can definitely help make a case stronger, it is not a necessary component of the case. And this is one of the reasons why VAWA self-petitioners can be very delicate, and why I would generally never advise a person to file an immigration application, or at least any of these, on their own. But VAWA self-petitions, especially because they are such a delicate art form, because there is no requirement for a police report, it does allow for all of these more subtle forms of domestic violence to be eligible for the VAWA self-petition, right? So here we are encompassing things like psychological abuse, financial abuse, sexual abuse that goes unreported in marriages, right? Things like that. And so if you aren't well trained or well versed in understanding the dynamics of domestic violence and understanding the requirements, the legal requirements for VAWA, these can easily go wrong. And they are a little bit of higher stakes here because the VAWA self-petition does allow the capacity to simultaneously file for a green card if the immigrant is married to a U.S. citizen. And so whenever we are filing green card applications to USCIS, the stakes are already higher because this is where in law enforcement, right? So if an application is denied, this is where ICE enforcement is often the highest when we are talking about people who have green card applications. And so I would never advise anyone to file one of these on their own. But they follow a very similar structure to family-based applications. So that last component, that the person be a person of good moral character, also means that people with certain criminal histories are just ineligible to apply for VAWA. That means that certain people with high immigration violations are ineligible to file for VAWA. And it does not, while it has some protections in place and some waivers that are eligible, it is not as wide sweeping as a U or T visa. So, again, it isn't, the immigration process in the United States is not easy, and these are just sort of considerations that we have to take into account. Of course, there are exceptions for a lot of the general rules under VAWA when you can tie a lot of what's going on to the abuse. So, like, let's say, for example, one of the common things that we see is that survivors are often the people who have arrests for domestic violence, right, where their abuser uses the legal system to either get them arrested or have restraining orders filed against them. And as long as that we can tie it to the abuse and show that it's part of a cycle of violence, then a person is generally okay, but it is an extra effort that we have to engage in, right? The next thing here is something that's called a battered spouse waiver. So this is for conditional permanent residence. So when you were married for less than 2 years before, when you file a green card application for your spouse, you were only given what's called conditional residence status. I should actually explain one of the things about coercive control with VAWA. So when we're talking about family-based applications, what happens is you have the U.S. citizen partner, and then the undocumented partner. The U.S. citizen applies for what's called a family-based application, right? Sponsors the other person, and it is that sponsorship, once it's approved, that allows the undocumented spouse to apply for a green card. However, while that sponsorship application is generally easy and has no requirement for an interview with immigration, that green card application that the immigrant puts in is subject to an interview when it's family based. So if they're between spouses, there is usually an interview that happens that needs both parties there. And this is where the coercive control comes in, because without that U.S. citizen spouse to appear at the interview and continue cooperating during the process, which can sometimes take about 2 years, you're stuck, right? And so this is where we see a lot happening, right? This is where the coercive comes in for VAWA. Sometimes it is a complete a complete, like, one, the partner is saying, I am not going to file for you unless you do all of these things. And sometimes it is the spouse filing an application and then threatening to withdraw it or not show up for the interview, or report fraud, right? That is one that we see all the time too, where abusers say, I'm gonna report this marriage as fraudulent and tell immigration that you were only seeking to marry me for my papers, right? And so this is where the battered spouse waiver comes in. Because when you have somebody who is a conditional resident there, even though they have their green card that is valid for 2 years, after 2 years, they have to reappear, file a joint application to remove the barriers on their green card status. And that also requires a joint interview with their spouse. So immigration does this whole process of conditional residency, they say, in an effort to decrease marriage fraud, right? To decrease the amount of fraudulent marriages that are out there. However, it is leaving survivors with yet an additional barrier, an additional thing that can lead to coercive control. Because even if a person marries their partner and receives their green card, if that green card is conditional, they will still need the cooperation of their abusive spouse in order to get their permanent green card, that green card that's valid for 10 years. So the battered spouse waiver and the VAWA self-petition are very similar in structure. The only difference is that you don't have to prove your abuser's legal status or that you two were living together, because you already did that in order to get your green card. But you do have to show that there was domestic violence that led to the breakdown of that relationship. And then the last one that I wanted to just sort of briefly talk about, because this one is the most complex of all, is going to be applications for asylum. And so here I'm really talking about affirmative asylum, which is a recently arrived person coming to the United States and filing an application based on domestic violence that they suffered in their country of origin within the first year of arriving to the United States. One of the biggest things that I want to talk about here is that when we're talking about affirmative asylum relief, that needs to be filed within the first year of the person entering the country. That is a very hard deadline. There are certain exceptions to that rule, but they are very limited. And the more time that goes by, the more difficult it is for those waivers to apply. Okay, next slide. That was a lot of information, so I'm totally okay people having follow-up questions here. The next thing I wanted to talk about was VAWA confidentiality. So we already talked about VAWA, the legal component, right? This is the social component that I was talking about. So the basic tenets of the VAWA confidentiality is non-disclosure. So it protects victims who have filed a protected case with DHS. The way that this works is that it applies to even me as an attorney. I cannot disclose when a client has filed a VAWA self-petition or a VAWA protected case to anyone who is not my client without some sort of express consent. But it also applies to USCIS. So the way that we see this work is when you are working with an attorney, which is another reason why I would highly encourage people to work with attorneys when filing these cases. If, like, let's say, for example, we have a scenario in which, a survivor who is still living in the home or who is entangled with an abuser who still has access to the home, if they were to find receipts, green cards, whatever it is, right? And they try to call USCIS to get information, even if they have that receipt number, right? The person's case number with immigration, the full details of the case, whatever it is, the abuser's name is registered with USCIS. So what will happen is if that abuser ever calls to get information about my client, I actually get a notice from USCIS saying that a party in a VAWA protected case has attempted to get information. And that's all they say, right? They don't necessarily say that it's the abuser who is the one who contacted, but I get notified of any person's attempt to get VAWA protected information. And so how we were seeing this happen during the Trump administration, this is such an amazing story of just like people really advocating for immigrants. During the Trump administration, so historically, whenever we have VAWA self petitions or U visa and T visa cases that are denied, there has been very little risk of ICE coming and enforcing deportation for these folks. It was one of the most glorious aspects of this humanitarian department, is that you really could file cases without any kind of fear of deportation if you ever, if something ever went left. And during the Trump administration, we were seeing that USCIS was disclosing the information about denials for U's and VAWAs. And VAWAs was the one that was like, wow, that one hit home. That one was like, wow, we've never seen this happen. And so what agencies started doing across the country was filing lawsuits against USCIS, saying they were breaking VAWA confidentiality and suing for every single step for that $5,000 fine, suing USCIS for every single disclosure that they did. And those lawsuits worked. And I actually don't know whether they got the money they were asking for, but USCIS stopped disclosing information to ICE, and so we went back to what we were formerly seeing around protections against enforcement if there were VAWA denials. So the next thing that VAWA confidentiality affords is abuser provided information prohibition. So again, this includes family members of abusers, crime perpetrators, whoever. If you were listed as, if that abuser information is provided on the application, they cannot give any information about that. So it protects all victims abused by a spouse or a parent, all victims in the process of applying for a U or T visa, and abused spouses of visa holders with VAWA work authorization filed. So the next is location prohibitions. So this protects all victims and requires that there not be any action at protected locations, so shelters, hospitals, certain places of employment, or that notices to appear. So if you are being given a notice to appear in immigration court, must state how they complied with VAWA confidentiality in order to serve that notice to appear. So there are pretty high protections for domestic violence survivors under the VAWA Confidentiality Act. Next slide, please. Oh, sorry, the VAWA confidentiality. So this applies to folks who are applying for VAWA. This includes the self-petitions that we discussed and the 751 battered spouse waivers and all other forms of VAWA-based relief. It applies to U visas, T visas, and abused spouses of these other employment-based categories. So EAG, and H visa holders. So not just for UNT, it's more expansive than that. Even though it's called VAWA, it does not only apply to VAWA cases. So there are certain exceptions. This is disclosures to law enforcement, national security officials, immigration cases where there's a higher level of judicial review, but it's only allowable for a legitimate law enforcement or national security purpose. And when it is being circumvented, it has to do so in a manner that protects the confidentiality of such information that is inherently protected under VAWA. So the benefit that's being granted has to really be greater than the whole public purpose. It also has exceptions for congressional oversight and data collection, but when that's done, it omits personally identifying information. And then another exception is adult waived confidentiality protection. So again, when a person says, you can go ahead and release my information. Next slide. So just a very brief know your rights around VAWA confidentiality and your immigrant rights in public spaces. You always have the right to ask if you're free to go, right? Always. And if the answer is yes, go. If they say yes, that you are free to go. You can also say, I don't want to answer your questions, or I'd rather not speak with you right now. Again, you have no right to an attorney. So the general of I'm not going to speak to you without my attorney present. It doesn't necessarily parallel in this universe. But you do have a right to not answer questions about your immigration status or where you were born. Definitely do not hand over any foreign documents such as passports, consular IDs, or expired visas. And if they say that yes, you are free to go, then you have the right to walk away if you're not being detained. If a person is detained, they have the right to remain silent. They have the right to say that they want to speak to an attorney, right? It does not necessarily mean that an attorney is going to be assigned to them, but they have the right to say that they are not going to speak. They have the right to refuse consent to a search, to refuse to sign documents. Um, there's uh, there's no right to lie or show false documents or resist arrest. So this is, where we find the most. Do not use false documents. It will only make it worse. And then understand that providing proof of foreign citizenship or informing ICE where one was born can be used as a basis for deportation. So this is why we just say you have the right to remain silent. You don't have the right to like lie, to say no, I'm born in the United States, and to be let go. But in these scenarios, almost every interaction with ICE can be used against you. So the remaining silent is often the best practice here. Next slide, please. And so if ICE is at your door, first thing is find out, are they police or are they ICE? It is very difficult to tell, especially recently. In the last 10 years, we've seen that ICE really tries to go undercover, and you really can't tell the difference between whether they're ICE or if they're just police officers. If ICE agents do not have a warrant signed by a judge, not by another ICE officer, but a judge, an immigration judge, it has to say immigration judge. They cannot enter a home without permission from an adult. You can ask to see a warrant and have them slip it under the door so that you don't actually open the door. If it's not signed by a judge, you do not have to let them in. If they're asking for a household member, then you can just ask for them to leave the contact information. You do not have to tell them where the person is, but you should not lie. Next. If ICE is already inside your home or a shelter to make an arrest, you can tell them there are children or other vulnerable residents in the home if it's true. You can ask them to step outside unless they have a warrant that's signed by a judge. And again, an administrative warrant that's signed by an immigration officer is not enough to enter your home. And the two most common forms that we see here are an I-200 or an I-205. Those are immigration ICE forms. It is not the same thing as a judge order. If they came inside without your permission, you have the right to tell them, I do not consent to you being in my home, please leave. If they start to search rooms or items in your home, you can tell them, I do not consent to your search. And if ICE is arresting you, tell them you have medical issues or need to arrange for childcare if that's the case, right? Again, this may not necessarily stop an officer from doing what it is that they believe they are within their right to do, but these are rights that you have, protected rights under immigration law. Next. So if you are detained by ICE, you have the same rights against self-incrimination. You don't have to share any information about where you were born, your immigration status, or any criminal history. You can ask to speak to an attorney instead of answering questions, but would highly encourage you to contact attorney or legal services as soon as possible if you are already in detention. The biggest thing, do not sign anything, even if there's pressure to do so, until you've properly had the opportunity to consult with an attorney, because some people may be eligible to be released on bond. And so it is best to not sign anything away, because ICE can sometimes pressure folks to sign away their right to bond, their right to be let out of detention while they're awaiting their immigration proceeding. And then have a plan in place for your family if a family member is detained. This goes along with what I was saying before about having very specific safety planning measures. Next. Again, carry the contact information of your attorney or legal representative. You already have one. Carry your Know Your Rights card that you can show to ICE. It's these little red cards. They're available for free through the IRLC. If you have a valid license, work permit, or green card, if you have one, then show it to them. Do not carry around false documentation, because that can be used against you. Next. So ICE enforcement protocols, enforcement actions are not to be taken unless the action is certified in advance to a specific process aimed at protecting victims, right? So again, we need to have these things signed by an immigration judge. So Generally, these are the protected spaces: shelter, rape crisis center, supervised visitation center, a family justice center, victim services program or provider, a community-based organization, or a courthouse in connection with any protection order, any restraining order case, child custody case, civil or criminal case involving or relating domestic violence, sexual assault, trafficking, and stalking. So certain jurisdictions, not California, but states like New York, have very specific courts for things like domestic violence, sexual assault, and trafficking. And so they are even more heightened, they have even more heightened levels of protection. Next. And that's all that I had for you today. I think that the some of the other things that were being asked were more specific, like some of the questions that came to us. So I will allow folks who had those very specific questions to come forward. But generally, so this is our contact information. When receiving referrals, they do go through our main phone number. We also do receive referrals through our 24-hour rape and battering hotline, which I'm pretty sure was provided to you probably by the last two people from our organization that presented. But that is another way for folks to get connected to services with us. But when they call the general number and can state what their needs are, then they can get connected to legal that way. Whenever we cannot assist, because as of right now, our family law team is down, so we are only providing immigration services and DVRO services through our case management. So whenever there is something that is either outside of the scope of the legal services that we provide, we do our very best to do warm handoffs or to give referrals for other agencies. But yeah, and if it's something that we can assist with, then we try our best to do it internally. Okay, I think that's all that I had. Oh, you know what? I did want to address one question that I thought was very interesting that came through, was around reproductive coercion. So reproductive coercion is it is embedded in the family law code. So while I actually can't remember off the top of my head if it's like a criminally protected statute on its own. It may fall under under the criminal statute of sexual assault or certain types of inappropriate sexual conduct, but it is protected under the family code. So that means that you can seek a restraining order for reproductive coercion. You can seek custody and other paternity issues under reproductive coercion. So it is recognized by the family code. There are criminal and civil remedies that are available based on that.
Thank you, Lizette. I think we just have like a few questions that came through the chat. It's a webinar, so I don't think people are able to unmute. But there was like two that were specific. One was like, do undocumented folks have access to the victim of crime services in California?
Yes, absolutely, absolutely, and then still can get reimbursed for a lot of the same for all of the same things. So rent assistance, doctor and medical bills, counseling, all of it.
Okay, and then the next one was for immigrants who have experienced DV and have children with a disability, are there higher chances of them obtaining legal status in the United States?
This is one, when we're talking about misinformation in the community, this is the highest way, right? That 10-year visa that people say that they can get. Unfortunately, the answer is like, it depends, right? This is like the third time now that I'm hitting you with that answer. But it really does depend. But one of the things that people should be aware of is that this is usually what this is commonly referred to as withholding of removal, and it is only available to folks that are in active deportation proceedings. So that means that survivors that have been here for decades and are already not in deportation proceedings, they've just been living under the radar, they have to actively put themselves in deportation proceedings in order to avail themselves of this remedy. So it is one of the ways in which immigration and notario fraud actually started running rampant in the last 10 years, is because people would go and say, hey, you're eligible for this 10-year visa. You have a person who relies on you, a U.S. citizen child who relies on you for support. You'll be fine. And what they don't tell them is that they are submitting like basically not real asylum cases in order to get them denied and get them put in active deportation proceedings. So it is a very risky process, and one that I would not advise.
The next question was, it's also specifically, if a woman was a victim of domestic violence and reported the DV, but it happened 10 years ago, is there a way they can still petition for any of the legal remedies that we reviewed today?
Yeah, absolutely. The U visa. The U visa has no limitation on how far back the incident happened. And actually, in California, there is a due to just advocacy that we've been doing for decades, there is a presumption of helpfulness in California. So unless the police actually have something that shows that the person was not cooperating, then the police, there is like this inherent you must have been cooperative unless we can show that you were not. So if the person, like, let's say, for example, the police may have purged the records or the person themselves don't have a copy of the police report, that presumption of helpfulness means that the certifier has to sign the certification unless they can find something in the record that says the person did not want to cooperate.
Okay, and then the next question was, can a partner apply for any of these processes if they are not legally married to their partner, but do have children with them? It said specifically this person had an argument with their partner and was pushed during the argument, and a police report was made.
So here again, we're in the U visa context, right? The VAWA is only available when there is a legal marriage between a person who is a U.S. citizen and, an abused party. So that would fall. If there is no legal marriage, then we are already outside the VAWA context. Here, we're talking about U relief.
I think this one was like a clarification question. It was after 3 years after the U visas are approved, they can apply for and for what? I think it was
Oh,
just a
green card.
okay,
Green card.
perfect.
Yeah.
And then we just got one. It says, any comments on how undocumented immigrants have been coerced or tricked into being moved to blue states as a political theater?
That's an interesting question. I mean, I don't think so. Being coerced to move, I think I would have to imagine then that that's coming from other states. This is a very real thing that happens, right? States just want to get rid of their immigrant populations, and sometimes they say like go somewhere else. It'll be much easier for you there, right? Um, but then, I mean, I think what's coming into the landscape right now is certain communities wanting to just like be more generally accepting of immigrant populations. We've definitely seen this happen in LA County, right? Where LA is like purportedly boosting up its services to accept like recently arrived children, recently arrived youth, and just like recently arrived immigrants. So it does get very dicey because I mean, like I can tell you, like sure, Los Angeles is saying that we're accepting all of these immigrants, and while the nonprofit sectors and all of these agencies that are providing hands-on services are actively involved in this, where's the money from local government to protect some of these services that are getting cut? Is not
Mhm.
coming. Is not coming. So maybe that's sort of the aspect of performative, performative acts that the person is alluding to. But I mean, we've seen, I can say that agencies like ourselves and other similarly structured agencies, like our fight to protect immigrant survivors has not shifted, but we have definitely seen a decline in local governments' commitment to keeping these programs operated and funded. And I mean, this is where we just sort of say like, yeah, maybe this is what it's performative, right? Because the things that are vital to us staying alive and to continuing to end this endemic, it's just not coming.
And then I think our last question, oh, it doesn't, how old can a case be, to be reported to file for visa or services?
There's no requirement. So as long as again, as long as the person, as long as we're able to get a certification for a U visa, then we can do it.
And I believe this is the last question. It's, what is the thinking slash preparation for possible change in direction due to the election? And what is the impact of Project 2025 in this area of law and services for vulnerable populations? And he said, I can respect that you do not wish to wade into this or the previous question, just concerned about how the institution of law will be affected in being able to support vulnerable populations like the ones we're discussing today.
So one of the good things about one of the minor good things about the way that our immigration system works, that it operates independent of our a lot of our other codes. So as a means to separate power in this country, we have codes like laws that are codified under completely different parts of law. And so the INA, which is our Immigration and Nationality Act, it is so difficult to change. This is why sweeping immigration reform is already difficult as it is. Why so much like sweeping immigration reform hasn't really happened since like IRA was passed in 1996. Things like the VAWA, VAWA, the U visa, T visa, those things are still codified under the INA, irrespective of like who is in presidency and what our congression looks like, right? So it is more difficult to change for the better, but it also means that there are certain protections that will not go away. Now, the things that are more difficult are like these informal policies, like what we saw happening during the Trump administration, right? Where the USCIS would just decide, like, we're going to do things a little bit differently now, right? Those informal policies are the ones that are the most dangerous to these populations, because they're things that are not codified under law, but just things that we have been able to sort of concrete based on good relations with these local agencies. So that is where, but this is also where there's so much more room for advocacy, right? Where like coalitions can come together to really impact change. And so this is probably our weakest and strongest point at the same time. So what I would say in preparation of these upcoming elections would be exactly what we saw during the Trump administration: heightened know your rights presentations, where people just like know what their rights and protections are against ICE and enforcement procedures. Additional layers of safety planning around children custody, like all of these different things. And then, making sure that people's documents are safely stored with people they can trust.
Thank you. And then I think one more question came in right now, and it's if a family member was there during abuse, would they qualify for help for residency as well, since sometimes family members all live together?
So it depends. It depends, yes. There are certain bystander eligibility criteria for the U visa. There are also certain things, protections for children under VAWA if like or if their parents were abused, or if like, for example, you can also apply for VAWA if like you are a non-abused spouse where your children were the ones who were suffering domestic violence. So there are certain qualifications, but it would really depend.
And then we just got one more comment, and it was wanting to thank you for tackling that difficult topic. And he said he hopes that independent balance of laws and government branches will hold up, and human rights will always be respected.
Yeah, as a country, we don't do great with human rights. It is just we think that we do, and I think that's the most dangerous thing, right? It's like just like people come to the United States because they think that our immigration law is so bountiful. It is those misperceptions sometimes that are the most dangerous. But thank you.
And those are all the questions today. And again, we just wanted to say thank you so much. It was a really great presentation. I feel like I learned a lot. And a lot of people had questions that you answered for them.
Thank
Um,
you. Yeah, I saw one. I saw one at the bottom that asked about VAWA for divorced. There is a two year limitation on divorce proceedings for VAWA. So if a person was married and is currently in the process of divorce, they have up to 2 years of the date of finalization to still apply for VAWA. And then I think, what did it say? It said if the victim has DCFS child abuse reports and the kids are taken away in foster care during some time, do they still qualify? Yeah, things like those don't affect VAWA eligibility, but things like divorce would. So as long as it's 2 years within the final judgment of divorce, it can still qualify.
Now we got a question about the presentation. We're going to post the presentation and the recording. It'll all be on our website, and we'll also send out a follow-up email.
Thank you so much, everyone.
And
Thank you.
oh yeah, go ahead. Go ahead, Anna.
Just one final reminder for everyone who attended to take the evaluation. Once you leave this webinar, it will automatically pop up on your screen. So just please take a few minutes to fill out our Survey Monkey. Super easy. It just really helps us know how we did and what future trainings we can provide for you all in the future. But thank you everyone for joining. And thank you, Lizette, for an amazing presentation.
Thank you.
Thank you, everyone.